Ladies and gentlemen, welcome to this meeting of the Standing Committee on Justice and Human Rights, where we are resuming our study of an act to amend the Criminal Code, Detention in Custody, Bill S-217. Today we have three witnesses before us who are going to hear as a panel, and then we'll be asking questions. So first, we're going to be hearing from Ms. Shelley McInnes-Wynne as an individual. Then we're going to be hearing from the Alberta Federation of Police Associations, represented by Mr. Michael Elliott, who is the president. And finally, we're going to be hearing from the Canadian Council of Criminal Defence Lawyers, represented by Mr. William Trudell, who is the chair of that organization. On behalf of Ms. Wynne, on behalf of all of the members of the committee, I know from all parties on a bipartisan basis, we all want to express our deepest condolences on the loss of your husband. I'm sure you've heard it over and over and over again. But just know that it's with meaning from all of the members of Parliament that I've spoken to from all parties, and we look forward to hearing your testimony today. So please, the floor is yours.
It's been 2 years, and what I like to call my journey of picking up the broken pieces. And I call it this because it is exactly what has been left for me and my family to do. To pick ourselves back up and try to put our lives back together, not only as a family, but as individuals. On January 17th, 2015, our lives were torn apart in just 4 seconds. Torn apart and left forever broken because of a career criminal, Sean Rain, who had been left back out onto the streets after a bail hearing. The bail hearing that didn't disclose his lengthy criminal record. 4 seconds that could have been prevented, and my husband would still be here today. Every day for the past 2 years, I have woken up and realized that Dave is really gone. And I start each day with a shower and crying in the shower. Every day I have to pull myself together and try to continue living and play the role of both parents, and that's not easy. Every day I have to watch my children grow and try to continue their lives without their father. Every day we are reminded so many times that he is no longer here. And it breaks our heart that we can't have those simple moments back that we would have every single day with him. The moments of hearing the cereal bowl hit the table in the morning and him asking who ate the last of his Fruit Loops. The simple moments of hearing the teapot rattle and knowing that it's 3 o'clock because Dave is making afternoon tea. I even miss the moments of him complaining about how I made the bed in the morning. All those little moments add up during the day, and we are reminded every single moment that he is not there. Our lives have changed in a way no one would ever understand unless you have walked this path. I am so grateful for the people that I have in my life that have had to walk this path as well. We call it a bittersweet relationship because we're thankful for each other, but we wish we had never met. And it's a life that we wish no one should have to live. There is not enough time today to even explain or tell you the struggles that we have to go through every single day of our lives and will continue to go through every single day. But I'm going to share just one moment with you that happened a few weeks ago. And this is a pretty significant moment. When Dave was shot, he was taken to the Royal Alexandra Hospital in Edmonton. And I had to go back there before, after this has happened. And I've thought that, that first meeting would be the worst, and I'd get it out of my system, and that would be it. And just recently, I had to go there for work. And driving there, I was very anxious, but was able to get through the day. And just before I left, I caught a glimpse of the emergency entrance. And then I saw an ambulance. And in those few seconds, I was taken back immediately to the night that Dave was shot, and reminded of everything that we had to go through in those 4 days to follow. In those few seconds, I could feel everything, the chest pain, the anxiety, the feeling of not being able to breathe, and the uncontrollable tears that were rolling down my face. It was like it was happening all over again. These are the things that we are reminded of daily, and trust me, it happens every single day. Not to this degree, but it happens every single day. We are constantly reminded of what has happened and that Dave is not with us anymore. This is so draining, not only emotionally, but physically. And this affects not only myself, but it affects my children, it affects Dave's mother, and it affects his sisters. By changing this one simple word, another family can be saved from going through this heartache and torture that we have to go through every single day. This is something that absolutely no one should have to endure. So I ask you to please do the right thing. Make this change and make our streets a safer place to be, not only for our law enforcement, but for everyone. This can affect the safety of every single person in our country, including you and your loved ones. Thank you.
Thank you very much, Ms. Wynne, for the very compelling testimony. And again, I think from everybody's perspective across Canada, our hearts break for what you and anyone else in this circumstance has gone through. Mr. Elliott, the floor is yours.
Thank you. Good afternoon. My name is Michael Elliott. I've been a police officer for 12 years, and I'm current president of the Alberta Federation of Police Associations. We represent approximately 4,500 municipal police officers across the province of Alberta. I wish to thank the committee for the opportunity to speak in regard to Bill S-217 today, an act to amend the Criminal Code for detention and custody. Before I begin, I would like to provide a brief synopsis of the terrible event that is brought to our attention on bail hearings. On January 17, 2015, our CMP officer, Constable David Wynne, was serving his community and his country. Constable Wynne encountered a stolen vehicle parked at a casino in St. Albert, Alberta. Constable Wynne identified a suspect, Sean Wren. Upon making contact, the suspect proceeded to shoot Constable Derek Bond in the arm and then shot Constable David Wynne in his face. Constable David Wynne succumbed to his injuries a few days later in hospital. Who was Sean Wren? Sean Wren was a career criminal with at least 100 offenses over a period of 2 decades. Between 2010 and 2015, Sean Wren was sentenced to a total of 10 years in jail. His charges included a variety of offenses, such as break and enter, theft, dangerous operation of a motor vehicle, possession of property under $5,000, house break-in and committing theft, obstructing a police officer, failing to attend court, assault with a weapon, and possession of property obtained by crime over $5,000. The list goes on. In front of you, you may have attachments that will provide a list of charges that he had to go through and what he was convicted of, what he was released on, and what charges were before him, unfortunately, during the event that unfolded. Mr. Wren also had a history of firearms-related offenses. He had been prohibited from possessing firearms for life. He was on conditions prohibiting him from possessing ammunition and firearms. Sean Wren had a total of 29 criminal code outstanding charges before the courts while he was on bail. This brings us to bail hearings. Many questions were raised to why Sean Wren was released on bail via a justice of the peace. We can sit here today to discuss what wasn't provided. The bottom line is that not all the information was produced. You may ask, what is required at a bail hearing? As a police officer in Alberta, I provide the just cause for detention. When a person is arrested, I have to provide what we call a bail package. This information is provided in 3 levels to a justice of the peace to determine if the accused is granted bail or remanded. The first level is what we refer in the bail package as the primary grounds. I provide information to ensure the accused will or will not appear in court to face his or her charges. Criteria includes the nature of the offense, the strength of the evidence, the accused's criminal record, previous court orders against the accused, and his or her behavior when arrested. The second of the bail package is what we call secondary grounds. This is for the protection of the public and the safety. The criteria includes accused criminal record and compliance with previous court orders, or is the accused already on bail or probation? The nature of the offense and the stability of the accused. The third level of the bail package is what we refer to as tertiary grounds. This information is to maintain the confidence in the administrative justice. The criteria includes the strength of the case against the accused, severity of the offense, and such things as was there a firearm used? What was the criminal record of the accused? And finally, what is the potential sentencing if the accused is convicted? The judicial system relies on all the evidence and information to make an educational and well-informed decision. When matters are before the court, disclosure and evidence are paramount to a fair and equitable outcome. The problem is not all the information is provided at bail hearings, as the Criminal Code states information may be presented. After Constable Wynn's death, a review of the bail system in Alberta was conducted, and the following is an excerpt from the study. I quote, "The bail system can also suffer from the perception that bail hearings are less weighty and perhaps less consequential than the other steps of a judicial process. The rules of evidence are more relaxed, the burden of proof is less onerous, and bail hearings do not generally involve the testimony of witnesses or experts. Most who work in the bail system, however, will be more likely to agree with a prosecutor who told the review, a proper show cause hearing needs to have the same sense of importance and urgency as a murder prosecution. The stakes for the accused and the public can be that high." A study by Ms. Nancy Irving recommended the following, which provides strong evidence and importance of the implementation of Bill S-217, making a small but significant change to Section 518 of the Criminal Code. The recommendations are as follows. Before a bail hearing, a police officer should provide the Crown Counsel with the following information, at a minimum: a copy of the information setting out in the criminal charges, an accurate synopsis of the allegations and circumstances of the offense, an up-to-date criminal record, including both a CPIC printout and join sheet, information on outstanding charges, and copies of forms of release of those charges. And finally, details of the accused's personal circumstances, such as residence, employment, and ties to the community. Changing the wording in Section 518 of the Criminal Code from shall to may by implementing Bill S-217 is the correct way to proceed for the judicial system and the Criminal Code. Bill S-217 is not an overburden of the system, in my opinion. Bill S-217 will not create any financial hardships on any level of the government. The requested information, in my opinion, is already available via the police to provide to the Crown at a bail hearing. I have personally acquired the aforementioned information via available programs police agencies have their use. In life, we make decisions. When making those decisions, we research, educate ourselves, and learn what is best before we forge ahead with our plans. This is no different with our judicial system. We want to make an educated and well-informed decision during bail hearings. The bill is not being about tough on crime. This bill is about being fair, honest, and open about crime for the public. In the end, we want to ensure the public has faith in our criminal judicial system, and we can look at every citizen in Canada, including those accused of crimes, and tell them we made a decision with all the information that was available. Our citizens deserve the truth. Bail hearings are no different. Thank you.
Thank you very much, Mr. Elliott. And now we will go to Mr. Trudell.
Thank you very much, Chair, honourable members of the committee. It's an honour to be here. I am Chair of the Canadian Council of Criminal Defence Lawyers, which in 1992 was formed as a council. And for those of you who don't know, where there is a strong criminal defense organization in a province, we have a representative. Where there is none, an organization like in the north, we have a representative. So we voice and assist on legislation from across the country from a defense counsel's point of view. Before we started, I said to Ms. McInnes-Wynne that I too thought that she was incredibly brave, and I acknowledged as best I can the pain that she has gone through. And I also said, and apologize in advance, that I would probably be saying things that she and perhaps Mr. Elliott didn't agree with. But it comes in the spirit of all of us trying to help and make the criminal justice system work better. And with the greatest respect, I hope that you accept these comments in the spirit in which they're given. Something has happened in this country in the last 5 years that is remarkable. Well, actually, I'm going to expand it. Maybe the last 8 or 9 years. And one of the things that happened was in Vancouver about 10 years ago, the Canadian Association of Chiefs of Police, together with judges, a couple of judges, decided that there should be a forum on criminal justice, reinventing criminal justice. And 50 people were invited to a closed-door meeting. And at that meeting, we found out, all the different stakeholders, that we have more in common than we have in disagreement. And that has led to the 10th. And it is collaborative study of criminal justice. The National Justice Committee formed Justice Efficiencies, which is a committee of 15 defense counsel, chief justices from the high courts and provinces, representatives of the Canadian Association of Chiefs of Police, and deputy ministers to meet in a collaborative sense to look at criminal justice issues. And I want to say this, that one of the common features in both of those studies, those programs, those committees, are the front-end management of the criminal justice system, the problems with bail, the problems with mental health. And I want to recommend to the committee the report of the National Symposium on Reinventing Criminal Justice and the report of the Justice Efficiencies, which has studied bail, studied early case consideration, and you're probably aware of that. Probably in every province right now, provincial governments are studying criminal justice because of the impetus here from Parliament in Ottawa in terms of looking at restorative justice, looking at criminal code, and looking at bail. And bail is actively being studied in just about every province. So I understand, I commend, for what it's worth, the persons who introduced this bill to try to deal with a tragedy, to see whether or not there needed to be legislative change. But the legislative change that you, and this is your job, not ours, that you may introduce and pass is legislation that affects the entire country. It is not legislation that responds to a terrible tragedy. So my respectful submission is, and I'll help as best I can, that we don't have a legislative failure here in this case. We have a systemic failure. And all of the factors my friend Mr. Elliott referred to, the primary, secondary, and tertiary ground, are considered every day by the courts. The failure to pass information down the line is a mistake, and it's a human mistake. But I would like to respectfully submit that as a result of that mistake, there has been energized attention. My friend has referred to Ms. Irving's report. I've just been told that Deputy Armstrong did a report in Alberta. You are considering this. Criminal justice is a live topic. And so I hope that when you consider these provisions, you look at this in the big picture and try to understand the impact in Nunavut as well as Toronto, in Prince Albert as well as St. John's. Thank you.
Thank you very much, Mr. Trudell. We very much appreciate all of the testimony that we've heard today. I'd also like to take this opportunity to welcome Mr. Fraser, Sean Fraser, to the committee today, replacing Mr. McKinnon. Mr. Dubé to the committee, replacing Mr. McGregor, and Mr. Diot, who's sitting in at our meeting today. Welcome, all of you. So we're going to start with Mr. Nicholson. Mr. Nicholson, the floor is yours, sir.
Thank you very much, and thank you, ladies and gentlemen, for your testimony here today. Shelley McGuinness-Wynne, thank you so much for coming here today. You've made a difference in bringing attention to this gap in legislative, the criminal code provisions here, and I want to thank you very much again for your testimony here today. Mr. Elliott, you pointed out that it's usually the case that that whoever's conducting these bail hearings gets all this information, and that it would be an exception to the rule if they didn't get the information with respect to a person's past either criminal record or breaches of bail or anything else. Is that correct?
I understand your question. You know, the systems that we have before us, which are what I refer to as CPIC and JOIN. JOIN is like a Justice Online Information check. So when we do CPIC checks of an accused, we get their previous information. And when I say previous information is what their convictions are and what charges were against that were withdrawn or taken away from them. And we do a JOIN check because JOIN can actually provide information to us that shows what criminal charges are before.
But in most cases, this is before the court.
That's correct, sir.
That's correct.
Yes.
Because one of the issues that we had the last time we were here, one of the witnesses was saying, well, you're going to increase exponentially all the time it's going to take to do these things. And I made the point to him, and you're confirming that most of this information is before the court in any case, isn't it?
If CPIC and JOIN are up to date, there should be no reason not to acquire that information. We do it on a daily basis. It's I call it protocol. Every time we arrest an accused, we do a CPIC and JOIN check to obtain this information to find out if we can release an accused on such as a promise to appear, or we have to, depending on the circumstances, present him before a justice of the peace to see if that person, he or she, will seek bail. That's
good. This is what we have to have. Mr. Trudell, you indicated that this was a systemic failure, but isn't that what this bill is setting about doing, is correcting that possibility that we could have a systemic failure?
No, with great respect, sir, the bill is a legislative change to the criminal code. The bill is a legislative change to the criminal code, and as I understand what happened, I've tried to get up to speed, and I'm happy that Mr. Elliott referred to it. I've read a couple of reports. I understand that and as a result of this, there was a decision of Chief Justice Whitman in terms of police officers doing bail hearings, et cetera, in Alberta. But what I understand is the information that may have been available, certainly was available someplace.
That's right.
Was not conveyed.
That's right.
And you can't legislate the failure to communicate, and that's what happened here. So in every case, I mean, let me say this. Most defense counsel will tell you that the bail hearing is the most important aspect of the criminal justice system because it's the front end. A determination is made as to whether your client's right under the charter is going to be or whether or not it isn't. And a client in custody starts in effect serving their sentence, and the pressure is incredible. And I can tell you with the greatest respect, after 40 some odd years of experience, bail hearings are taken very seriously by Crown Counsel. They're taken very seriously by
justice. This is why they have to have all the information before them, don't they?
Well, you don't need legislation, with greatest respect, to tell someone that they need the information. And the bill, with great respect, creates problems.
In what sense?
Well, okay. In what sense? Let me suggest this. Let's look at 518C and the replacement sections. Let's just look down to show the circumstances of the alleged offense, particularly as they relate to the probability of conviction of the accused. That's nothing new in some respects, okay?
No.
But if you're putting it in there, what does that do? Does that mean that Crown Counsel has to make sure that they have more evidence to put to a justice of the peace, and it becomes almost a trial as opposed to, and we, the system, just cannot afford that. We are concerned right now with time and pressure in the system. So right now, one of the factors that is taken into consideration in the tertiary ground is the strength of the Crown's case. Okay? But if you're going to mandate that the Crown has to produce that evidence, what does that mean? It's not available yet. The police have not done it. What you get at a bail hearing is a synopsis because the file isn't ready. So what you're doing here is you're introducing a potential step that is absolutely impossible with the resources we have, will add to the problem of Jordan. And so that's one thing. To prove the fact that the accused has previously been convicted of a criminal offense, obviously, secondary ground. That's right. To prove the fact the accused has been charged with or is awaiting trial for another criminal offense, an indictable offense, it's a reverse onus. Right. To prove the fact the accused has previously committed an offense under 145. Those are the administration of justice offenses. And I would, with respect, would suggest that every police officer, every judge, every defense counsel, every Crown counsel in this country would say that we have a real problem with the administration of justice offenses in the criminal system being prosecuted and loading up the remand. So this, as I read it...
Does that make the argument that the court shouldn't hear about this information? If somebody has breached the terms upon their release or something, let's say they've breached it 15, 20 times, don't you think that's relevant for the court to decide?
Of course it's relevant. But why have they breached 15 or 20 times?
Well, because they may be criminals. I mean, I don't know. You know what I mean? Like that happens.
With the greatest respect, they may be persons, and you will find in the studies of the National Symposium and justice efficiencies that are not they're not defense counsel, that the vulnerable. I'm not talking about this person because we're not passing legislation for this in this particular case. You will find, and the studies will show, that it is the vulnerable in this country who face the administration of justice offenses more than anyone else. And I didn't come up with that. I didn't come up with that. That's the studies that have been brought forward. And so I don't know whether that assists, but your colleague beside you is wanting to.
But the chair is the one who will ask who's going to speak, and Mr. Cooper will certainly have his opportunity. But now we're about 8 minutes in, so we're going to move to the next questioner, which is Mr. Fraser. Mr. Fraser?
Thank you very much, Mr. Chair. Thank you all very much for being here today. And Ms. McInnes-Wynne, I echo the comments of the chair and that have already been mentioned for thanking you for everything that you have done bringing this forward to today, and obviously for being here and sharing your story with us. And I'm so sorry for your loss, but thank you so much for being here and the courage it took to do that. I'd like to, Mr. Trudell, ask you a question. I'm going to ask you a question on 515.10 first, the justification for detention in custody. And this bill seeks to add a couple of factors on the third ground of reasons or justification for bail detention. Now, the rationale as put forward for this bill is to ensure that that the relevant evidence is always presented to the court or to a magistrate in a bail hearing. And I'm wondering, it seems as though these additions to 515.10 on the third ground seem to expand the ability for a court to detain a person, or it's giving another kick at the can, if you will, on things that have already been considered in A and B of the justifications. I'm wondering if you have any thoughts on that, and if you believe that these grounds added in 515.10 would be useful.
And, sir, are you referring to Roman numeral 5 and 6 in the bill?
Correct.
Okay. With the greatest respect, I don't think they add anything to the existing system that we have. If an accused person has failed to appear, then immediately there's going to be a problem on the primary ground. So in other words, if I've been charged with a criminal offense, the court wants to know that I'm going to show up. So that's the first thing. Is he going to show up? Does he have roots in the community? And that may lead to some restrictions. The fact that an accused has failed to appear in court on one or more occasions when required to do so, this doesn't say the accused has been convicted of a criminal offense. It says the accused has failed to appear. It's too broad. I mean, there's lots of reasons why people may fail to appear. That's not what we're concerned about here. If the person has a record of failing to appear, and that record is not excusable because of vulnerability, like it might not have been with this man, then that person fails on the primary ground. But that's vague. It doesn't add anything. A is of concern. The accused has failed. It doesn't say he's been convicted. The fact that the accused has previously been convicted of a criminal offense, has been charged with, or is waiting trial for another criminal offense. But that's already there. That's the secondary ground. So the secondary ground is, if we let this person out, is he going to interfere with the administration of justice, like interfere with witnesses? And does he have a history of the revolving door? It's already covered in the criminal code. So it doesn't add to what we have, and
Do you see it, Mr. Trudell, can I ask, do you see it, you say it doesn't add, does it expand at all the ability or the likelihood of a person being detained that otherwise would not be?
The fact that an accused has failed to appear doesn't say has been convicted of a criminal offense of failing to appear. That expands, no question in my submission. But how this is interpreted, whether or not there's a new sort of thrust on Crown Counsel to not follow the law as it is, as guided by the courts and Morales and Pearson and the Supreme Court of Canada, I'm concerned about it.
Could I now turn, thank you for that, to 518, and under 518 sub 1 sub C, Roman numeral 5.
Right? To prove the fact the accused has failed to appear in court on one or more occasions when required to do so?
And in Roman numeral 3, it's to prove the fact that the accused has previously committed an offense under section 145, which deals with failures to appear. What, if any, difference do you see between Roman numeral 3 and 5 here?
I don't see any difference, really, on first reading. But this is the issue that is being examined by committees right across the country and by the Department of Justice. This is the administration of justice offenses, is one of them, that contributes to the enormous number of persons in remand in the jails. So,
and I'd like to turn to Mr. Elliott, if I could. In that same section 518, the fact that the Crown would now have to lead evidence regarding the circumstances of the alleged offense to be considered. Do you see that causing any delay? I know we can talk about criminal record and producing failures to appear may be easy, but can you respond to what Mr. Trudell said, that if we now put an onus on the Crown to have to show or demonstrate what the circumstances of the offense were, even in cases where normally that wouldn't be a ground that the Crown would rely on, it's now their onus to show this evidence before the court. Do you see that causing any delay with regard to producing that information? And if it does cause delay, what happens to the accused in the meantime if he has to come back for a bail hearing the next day? Is he released in the meantime?
Well, if I understand your question correctly, if a Crown has to provide, say, an extra 5 or 10 minutes to prove the onus on an accused, I look at it from this perspective. If I'm taking 5 or 10 extra minutes to provide all the information that is available to a justice of the peace or to a judge, I'd rather take 5 or 10 extra minutes to provide all the information that I have available than take an opportunity that something may, I'll say, slide, for lack of better terms, and then somebody unfortunately get out and create havoc or an issue like we've seen before us. Okay. That's my understanding, my take from that, because to me, maybe 15, 20 minutes. The bottom line is all the information is being provided, and that's what's important, is making sure all the information is out there.
Thank you, Mr. Elliott. Can I ask Mr. Trudell to just briefly comment?
Yep.
it's not 5 or 10 minutes. It's not ready, hasn't been prepared. And if that's going to be introduced, then the defense has to challenge it. And you're going to have a trial at the bail hearing. It's just not 5 or 10. If in 5 or 10 minutes, Crown Counsel could be better equipped to put a bail hearing together, then I'm all for that. But we're talking about the case, and the police are under such stress in terms of getting disclosure that it's not going to happen in 5 or 10 minutes, because police officers aren't going to be able to put it together. Their cases are still developing. They got reasonable and probable grounds to charge, but a lot's going to happen between then, preliminary hearing, pre-trials, all the rest of it. So Crown Counsel, Defense Counsel, Justice of the Peace are under great pressure to move the clock, to move the yardsticks. And I see this as absolutely weighing down a bail hearing. And right now in this country, it is very strained, the bail courts, absolutely strained. Sometimes you wait for briefs to show up for hours before a bail hearing takes place. So it's putting unnecessary pressure on the police and the Crown, and it doesn't solve the problem. Because at the end of this, and foremost, is the accused's right to bail. And that has to be kept in mind here. So I see this, and the colleagues from the council and across the country, when they looked at this, they thought, my God, how is that ever going to happen now with the pressures on the system?
Thank you very much. Monsieur Dubé.
Monsieur le Président.
Yes, Mr. Chair, thank you.
I also want to offer my condolences and just say how being involved in the process, how challenging that must be, and the fact that you're taking the time to do it is certainly remarkable, and we thank you for that, for what it's worth. Mr. Elliott, I want to ask a question about some of the issues that were raised when this bill was before the Senate, and in particular with regards to the Canadian Police Information Center. And some have, in the Irving report, it was mentioned that some of the information can be outdated. It's sometimes difficult between jurisdictions for a whole slew of reasons. I'm just wondering, given that we're dealing with the bill, but there's the other sort of moving parts around it, the information for the bail packages and things like that. Just wondering what your thoughts are on that, and if this bill was adopted, would anything need to be done to sort of fix that structure and make sure that law enforcement was able to provide the right information so that the process could go forward in an as unhampered way as possible?
Okay, from my perspective of that, I know CPIC has been behind on their records, information that's provided in there. That's why I use what we call Join. And through Join, I can get updates of information that's not been added to CPIC at that time, so I can find out. There's been many times that I'll pull a record on an accused, and it'll be, say, up to, say, 2015, and maybe nothing added after that date. I do a Join check, and I can acquire additional information on the accused that has not yet been potentially added to CPIC. So that way I can use two systems to provide an up-to-date information on the accused. Does that help answer your question there, sir?
Sure, and I guess in part, but I'm also wondering, just even between jurisdictions for something, let's say, crimes being committed in other provinces and things like that. My understanding is that there are some kinks that need to be worked on that level. What's your perspective on that?
It's very difficult for me to, I can speculate on other jurisdictions because I can, on my own, my background in information is just dealing in Edmonton and specifically Alberta, so it's very hard for me to provide. I can provide information on what occurs in Ontario or what occurs in BC. I don't know what programs are available, but like for Edmonton, for example, from Alberta perspective, we have additional systems. We use ePros, for example, and anytime that there's an accused dealt with in Edmonton, we have a record of that person. I can't, unfortunately, answer what's provided in Ontario or what's provided in BC. I don't know if my colleague here at the table can help provide any more information on that.
There is problems in communication between forces, but I think best efforts are made to make sure that CPIC is up to date. CPIC is a national program, so sometimes it falls through the cracks, but really I think that it's my experience that usually when I'm going for a bail hearing, the police have pretty well got that information that's available on CPIC in the Crown's file.
So I guess my question is, and hypotheticals are never safe territory in the work that we do, but if I may, would it be something that would be important to look at from the government's point of view if this bill became law to improve those systems and perhaps look at what's happening in different provinces to make sure that, from your point of view with the work that you do, to make sure that the information is as readily available as possible to maybe avoid some of these delays and other things that are sort of being raised as possible consequences of this law?
There's no doubt in my mind that we need continuing to study and look at our system, our judicial system. It's very fluid and it's ongoing. You know, we're here before today looking at Bill S217. CPIC is this one system that we have across the country that, in my opinion, continue to be updated and be as accurate as possible. There's no doubt in my mind that there's other systems across this country that we need to continue to expand, adapt, and learn, and so we can help all jurisdictions together and all, whether RCMP or municipal police forces, that we can work together. So, to me, this bill in the judicial system is one small step to trying to increase, be more proficient, and make sure all the information is available to all of our colleagues.
Thank you. Monsieur Trudel,
Mr. Trudel, my next question is also on the jurisdictional issue. As you know, the provinces are in charge of the administration of justice, even if the criminal code is federal jurisdiction. And so my question is to know, what is the burden on the provinces that would be created by this bill, and how can we address potential consequences? For example, in Quebec, the fact that there are delays in appointing judges is creating an administrative delay, and that's very problematic. That comes up, and it comes up regularly in Quebec. How do we deal with this reality and ensure that the burden on the provinces is not unduly increased by legislative measures?
We're looking at criminal justice issues. We have historically looked at a silo approach. Health not at the table with justice, corrections. And it's the same thing with provinces, my respectful submission. So you would benefit, I think, the committee from knowing what happens in the provinces and what is going on. So I know right now in Ontario there is a very vibrant bail study going on through the ministry. And you may benefit in deciding whether this bill is necessary to find out what's going on in the provinces and how this bill may impact them. But there's no question about it. Let's just say, for the purpose of this discussion, that if my interpretation of the onus increasing to show the strength of the case, what that does is seriously impact on the Crown's ability to run a file. And that means instead of 3 files a day, it might be 1. And so, and what it means is you need more Crown counsel, you need more judicial officers, you probably need more police officers in charge of getting that material together. So when we make a decision in the system legislatively, the repercussions to make it work on the ground really will go out to the provinces. So I could only begin to touch the tip of the iceberg in terms of the work that's being done by the provinces, who, as you absolutely point out, are in charge of the administration of justice. And that's what happened in Jordan. I mean, all the provinces are trying to react. So I think that with great respect, the committee would benefit from hearing from some of the provinces in terms of what they're doing and in terms of the impact of the bill.
Merci.
Mr. Biddle.
Mr. Trudel, I'll start with you. In terms of, we'll start with the amendments to Section 518. In terms of Roman numeral 1, Roman numeral 2, and Roman numeral 3, perhaps, the third one, is this a symbolic change? Because with every Crown Counsel I've spoken to, every police officer I've spoken to, this is evidence that's led automatically. if we were to change this, those particular sections, and I'll leave out sub 4 at the moment, is that a symbolic change, given your experience in the criminal justice system?
I think it is symbolic, because I think that but it creates I think it is symbolic in many ways, and that's sort of the concern I had with apologies as I started.
So, in building on what you said, and I've heard this, and symbolism is important. We're in politics, so that's a true statement. But in terms of overstating the public safety benefits to the changes to those particular sections, do you see any change to public safety in those 3 sections if it's changed from may to shall?
I think that the problem is that we are maybe creating problems in the criminal justice system that is under stress and being looked at by the federal government and by provincial governments. And let me just say this, if I could. We are sitting here and you are working very hard, and I'm a defense counsel, a police officer, and a victim here talking about the bill. And the public out there more generally really doesn't understand what we're doing. The public sees a person who should have been detained out on the street creating a terrible situation. And the public says, the system must be wrong, there's something the matter here. But when we look at it and we try to explain to the public, I think that they would understand that you don't make legislative changes if they're not necessary because of the impact across the country.
And the next clause, and we heard in reference to sub 4, the potentially significant burden it would have on the criminal justice system. Let's take it back to basics, though. In terms of going to walking into the courthouse in Toronto or any jurisdiction, can you give an idea to the committee how many matters might be heard by a justice or justice of the peace in terms of a bail list that they're expected to hear?
If every bail was a contested bail, we'd get nothing done. So there is real hope that there's front-end management, and this has been a problem, so that Crowns can make decisions about release and not be concerned about risk aversion. And so you need that front-end management, because you cannot ask for a detention order in every case. And sometimes sometimes detention orders are asked for because there's not enough information, or because it's easier to let a justice decide, and that's not the way the system should work. So to start with, defense counsel hopefully will know something about the case. If it's duty counsel, go to Crown Counsel, who already has some information from the police as to the background. And sometimes the police recommend conditions, right? And so hopefully that's done in the front end. But if that's not done, then you are going to have probably 2 or 3 contested bail hearings at most on a day.
But how many typically would a justice hear based on, in the current system, how many without the amendments? How, approximately, given your experience? I know it'll vary from day to day, but...
On a daily basis?
Yes.
I'd say at least 5 to 10 each day. And then sometimes you see in courts, in trying to deal with this, have administrative things that are foreign to some other courts. So one of the jurisdictions, and I don't want to pick anyone in particular, but in Brampton, Ontario, which is a hugely growing municipality with a modern court building that is no longer adequate. And bail hearings are incredibly stacked up. And it's not just what happens in the courtroom, it's getting the information.
Thank you. I'd like to turn to Mr. Elliott. You said, based on your opinion, this wouldn't be a burden on the judicial system, but we've heard from Mr. Trudel that this could be a significant burden on the criminal justice system. And in speaking with police officers and chief of police in my riding, they're fully aware of the Jordan decision and the pressures that it's putting on. Given what Mr. Trudel has testified to, would you care to re-examine your opinion that this has no burden on the justice system? Because seemingly it has a potentially substantial burden on the justice system.
Okay, what I'm referring to when I said there's no burden is that when I provide a CPIC printout for an accused and I do a join check on the accused, I have all the information I have to show that what is his or her convictions and what a list of potential charges that are still before the courts on the accused. For like this case of Mr. Rennie, 29 outstanding criminal charges that were still before the courts.
But going ahead to, again, the sub 4 section, and Mr. Trudel testified that with the type of evidence that is now would be mandatory to put forward, granted the CPIC printout, other items like that very quick and are done as a matter of fact, if we have to provide, or if defense or the prosecution has to provide that information, couldn't that potentially cripple the criminal justice system based on what you're hearing from Mr. Trudel?
I'd have to speculate if it would cripple. Would it slow the system? I would say yes, but from my perspective, I think that delay, for lack of better terms, I think is necessary to provide that information to a justice of the peace, given whatever the charges against them. I think the justice of the peace deserves to know all the information on the accused.
And just one final quick question, and I mentioned it to Mr. Trudel, in terms of the changing from may to shall with respect to Roman numeral 1, Roman numeral 2, Roman numeral 3, it really is a symbolic change because you yourself testified this is something that happens as a matter of fact. And since there's no criminal consequence or consequence of any kind for a mistake occurring, these mistakes can happen again, and there's no consequence to it. So if these actions already happen as a matter of fact, there's no consequence to doing it. Isn't this a symbolic change, and we're overstating the potential public safety benefits of this bill?
Well, with respect, that's my submission.
Or sorry, that was for Mr. Elliott.
I'm sorry.
Yeah.
I apologize.
If I wasn't clear, my apologies.
Yeah, and sorry, you may have to repeat that again because I thought the question was being directed here to my colleague, actually.
In terms of Mr. Trudel's testimony, he has testified that it's a symbolic act, symbolic change, because you've testified that as a matter of fact, you've provided most of this information without question. Without these changes, this information is going to be provided. So if we're changing clause Roman numeral 1, Roman numeral 2, Roman numeral 3 of the second of section 518, if you're doing that as a matter of fact anyways, and there's no consequence for a mistake, it's a symbolic change. Symbolism is important, but I think perhaps, would you admit that this is as a symbolic change that isn't going to change how the criminal justice system is run, just those three particular sections?
My opinion on that, if it's symbolic or not, even though I provide that information, I would like to ensure that information is provided to the justice of the peace, because even though I passed my file on for a bail hearing, I do not know if that information will be presented. So if we can ensure that it is presented, then we can know that information is provided to the JP.
Thank you very much. May I suggest, given that we started a little bit late, that we now go to different members of the committee that have shorter questions, that we allow everybody to participate at this point instead of doing a full other round? Is that good with everyone? I'll start with Mr. Cooper, since I know he has several things to say.
I've got a couple of questions. If I could beg your indulgence, Chair, thank you to the witnesses, especially Ms. McInnes-Wynne, for your very important and powerful testimony. My first question, I have a question for all three witnesses. Mr. Elliott, you have over a decade of law enforcement experience. We talk about delay, and you talked about CPIC, and it's my understanding that in order to access CPIC, it's really keystrokes away. Is that correct?
Yes, that's true.
and it takes how long for you to access CPIC with information on prior criminal convictions, outstanding charges, and failures to appear? Give us an idea.
If I had to run an accused on CPIC, I can obtain the information probably a minute.
A minute. And how long would it take you to get it to Crown Counsel?
It'd be printed off. Either I can fax it, scan it, or just email that to my colleagues.
Okay, so a matter of minutes.
That's correct.
That's correct. Okay. Now, Mr. Trudell, you said that this information is almost always presented at a bail application hearing. Why would it be almost always presented?
I'm sorry?
You said that outstanding charges, failures to appear, prior criminal convictions, that type of evidence is almost always presented at a bail application hearing. Why is it?
Because a judge, or a justice of peace as it may be, has to make a decision about whether an accused person is going to be denied liberty. And he does it in a graded step. Primary ground, secondary ground, tertiary ground.
Exactly, and without that information, it would be pretty tough for a judge or a justice of peace to make a determination, wouldn't it?
Yes, obviously.
Obviously. And so that's why the heart of this bill is to change the word may to shall. And to that point, Ms. McInnes-Wynne, there was some suggestion about symbolism. And there was some suggestion at our last committee meeting that this might delay a bail application by 5 minutes. We have in front of us the rap sheet of Sean Rain. And that rap sheet was not presented at the bail application hearing. So, and as a result, her husband isn't alive. So maybe if you could talk about symbolism, what your comment would be to that.
You know, that information was available in minutes. And again, what Mr. Elliott had said is that who would not want to have that information available to them when making that decision on whether or not that person should be back out on the streets or not. Imagine what that person is feeling right now, how they're living with themselves, knowing that they let that person out and they went and killed someone. And people like that are walking the streets every day. Fortunately, it's not happened that we know of again, or has happened before. But it takes minutes to have that information, just minutes. And if you were to stop and think about how those minutes could affect you as a person, because that could have been anybody. It could have been easily one of you that evening that he decided to take his anger out on. Yes, my husband was an officer and they're in the front line of things, but it could have been anyone. But it only takes a few minutes, and why would you not want to know the information before making that decision and letting that person back out onto the streets? It's just as simple as that.
Mr. Fraser? Sean, I'll come back to you.
Thank you very much. I greatly appreciate the testimony of all three of our witnesses and the perspective that each of you have offered. I have only one question, and it'll be aimed at Mr. Trudell. My gut reaction when this issue came before the House of Commons was that I want to do my part to make sure that, to the extent that it's possible, all bail decisions are made with full information. And I think everyone agrees on that much. My concern is when I started to think about the potential implications of this policy. From my own background was in commercial litigation, and I've had colleagues before show up in court where the rules required, as a mandatory feature of the application, they introduce affidavit evidence in support of that application. What happened when you try to make an application without that evidence is the judge is required to dismiss the application, and the person who bears the burden of proof has their application rejected. A concern I have, and I have no background in criminal law, so I'm looking for your opinion to inform my own open mind, is that if the Crown were to show up and simply make a mistake, I think whether it's mandatory or not, a mistake will happen at some point again. We can't legislate against negligence. In the event when this inevitable mistake happens again, will the judge be required to let the person go who should otherwise be kept for failure on the Crown's part to discharge the burden of proof?
Let's start with the police station. If the police officer at a station, officer in charge, has the power to release, and there's no information in CPIC or whatever about this person's background, then that person will probably be released from the station if the officer can do it, because there's no reason to hold them. And if it's subsequently found out, and it probably would be pretty quickly, that it was a mistake, the person could be probably rearrested. If you get into a bail hearing in front of a justice, an accused person has now been in custody for at least a day or two, and there's no information before the court. It is the obligation of the court then to ask the Crown whether he's showing cause here. And if the Crown has no evidence, then that person will be released. There is no question about it. But there's another side. That person could be detained wrongfully. That person could be detained by a lack of credible evidence. There's a lot of people who are in jail who, if we had that extra 5 or 10 minutes to find out something about their background, not this man's background, but their background, a history of mental illness or addiction, whatever, then a different result may occur. And what the different result may be is a bail program, a bail supervision. So we can't legislate to prevent human error. But what's happened here is, like, in the last few days, I've been overwhelmed by all of the steps and studies that have been done in relation to this case, especially in Alberta. So we learned from the mistake. So even the point where there's a reference taken, and Chief Justice Whitman says no, police officers can't do bail hearings other than summary convictions. So the system has responded to this human mistake. And I think that you can benefit from how the system has reacted and is trying to address this terrible tragedy. And I would say again, it's not a legislative issue here. And that's the problem.
Just in the limited circumstance where, through other potential evidence, perhaps it's the testimony of the officer, the nature of defense, whatever it might be, it's apparent that the person should be detained. But if this provision made mandatory the adducing of a criminal record into evidence, would the judge not then be hamstrung to have to let the person go?
I'm sorry. My mind faded for a couple of seconds. Could you ask me that again?
Certainly. I'm concerned about what I think would be an exceptional circumstance where the Crown, through evidence such as the testimony of the officer who made the arrest or whatever it might be, determines that the person should be detained. If a judge is required to have a criminal record and someone makes the mistake, despite this other evidence suggesting they should be detained and there is no criminal record, would the judge not then be required to let this person go?
No.
Okay.
Because the judge is going to apply the first, primary, secondary, and tertiary ground. The fact that the person doesn't have any criminal record, the fact that it's not available, if the facts as presented to the bail at that particular point in time determine that this person should not be released, let's just say they are from Alberta and the offense takes place in Ontario. They're not going to be released unless there's a cash bail because they may not show up. They have no roots. So there's no question about it that the Justice of the Peace can make a decision, not based on even a criminal record.
Thank you.
Mr. Dubé?
Yeah, I want to just have one quick question, so it won't be long, Chair. I just wanted to ask Mr. Elliott one last question about just how the police will operate, law enforcement will operate under this. And I'm actually more asking because I'm not, without being an expert, I just want to make sure I understand properly, because I know that in the Senate committee, the Canadian Association of Chiefs of Police raised a concern, but it was more of a question as to how it would change the burden of proof. So the burden of proof is very different in a bail hearing than in an actual trial. And so the concern that was raised was that maybe the burden being heavier would actually prevent certain, hearsay and things like that that could be perhaps lighter forms of proof, if I can phrase it that way, from being submitted. Is that a concern that you share? And if so, what could we do to rectify that?
Well, from the Alberta perspective, my colleague has mentioned something that right now police officers cannot provide bail hearings unless it's a summary conviction. So it has to be a prosecutor, a Crown. So in this case, a Crown is providing that information because that's basically police officers, from my perspective, should not be doing bail hearings. We're police officers and we're upholding the law and we're doing our job. Our job is not to do bail hearings. So to help from your perspective, that's the Crown's obligation to make that occur, to make sure all the information is provided.
If I may, perhaps in the context of preparing the bail package, though, just when what comes on you?
From my perspective, nothing will change from that, because I'm still going to provide your CPIC printout, your joint printout, and all relevant information that I have on that accused to, in this case, provide that bail package to the Crown when the Crown can present to the Justice of the Peace.
So as law enforcement, your approach to preparing that package with or without this legislation would not change?
That's correct.
Okay, thank you.
Mr.
Thanks,
Biddle, then Mr. Cooper, and Mr. Fong.
Thank you. I'm a civil litigator. I do apologize, but there we go. We're all on the same page. It's very Canadian parliamentary moment. Everyone apologizing to everyone.
I was just told that was an appropriate apology from me.
Having never seen a consent bail hearing or a bail hearing at all, could you please briefly describe what goes on at a consent hearing, how often it happens, and would these amendments limit the ability to have these?
What goes on in a consent bail is this. Crown package is available. Prosecutor, whether for the province or the PPSC in drug matters, looks at it, looks at the criminal record, looks at the accused in a drug case, finds out whether there's an addiction issue, looks at whether they have roots in the community, maybe whether they have a surety, okay? And if those boxes are ticked off and they have a discussion with the officer in charge, then they will consent to a release on terms that the officer may help with. Look, we should have a curfew for this person. Or it's okay, but they should report, whatever conditions reflect the case. So, and that's how it works. And that's how it works in, I'm going to say, 60%, maybe more, of all cases. So in other words, you and I are preparing to appear in front of the committee. We're working on what we're going to submit to the committee. You're going to ask me the questions. I'm going to ask you and then we're going to go to the judge and say, we have agreed on this. And so what that means is, and Crown Counsel is going to ask the proper questions. And then what you do is a defense counsel may show up, okay, or maybe get in early and say, you know what, I've got a surety, I've got the bail program, I got a drug addiction program, so we build that in. So then you add the third important party into that consent release. It's not done like that, okay? And sometimes what happens is defense counsel and accused persons, if they're not represented, often agree to all kinds of terms just to get them out. And then you find that they don't have a house, they don't have an alarm clock, they can't follow those terms. Or sometimes Crown Counsel will say, well, we want these terms and they're not necessary. So, but that's what happens in a consent bail. The work is done in advance.
Would these amendments to the code limit the ability to engage in that activity?
Absolutely. You have number 4. If number 4 is there, number 4 says to show the circumstances of the alleged offense, particularly as they relate to the probability of conviction of the accused. That's a trial. And that bail hearing is going to take a while, for sure. So, yes.
My final question, likely.
Sir, can I say that Crown Counsel will be forced not to consent? Right? and then the courts are going to implode.
Do you see charter issues with this bill?
We start off, and it's hard for the public to understand when someone is charged with an offense, but we start off with a presumption that this person deserves to be in the community according to the charter. Anything that seems to interfere with that, which is not reasonable and not proportionate, will face a charter challenge, no question.
So I guess just to follow up, you don't see this as, especially Roman numeral 4, as reasonable or proportional?
I think it's a nightmare.
Fair enough.
Thank you, Mr. Falk.
And I too want to echo the sentiments that my committee colleagues have echoed to Mrs. Wynne, and thank you for your presence here today. I don't know if you have a copy of this in front of you or Mr. Elliott has one, but my understanding of your testimony thus far is that you believe strongly that had this information that's in this document been presented at the bail hearing that released Mr. Rains, he would not have been released, and that we wouldn't be here today, and that we wouldn't be having this discussion because you wouldn't even know who I am.
Exactly. This took how long?
I can print that off I can print this off in about 30 seconds to a minute.
Okay, and that was my next question to Mr. Elliott. How long would it take to produce this information? Not necessarily in this format, but the information that it could be legible presented to a justice. You say 30 seconds to...
CPIC information can be obtained within 30 seconds to a minute. A join check is another computer program we can check, and that can be done within a minute and a half to 2 minutes.
Right. So I don't see a huge backlog created because of that 3 minutes of time at the outside to provide the information that would have been so terribly relevant to the case with Mrs. Wynne's husband, where...
That's correct.
With Mr. Rains, where Mrs. Wynne's husband's life was forfeited because of a lack of information. And so, Mr. Trudell, I want to just direct a question at you. First, I want to make an observation. You said that in the end, at the end of the process, the end of the conversation, the accused's right to bail is what's preeminent. Is that really what you believe?
Absolutely. And that's in the interest of the public.
Okay. I don't necessarily share that that's the most preeminent thing, but I understand that you're here representing defense counsel.
No, I'm not. I'm here as a member of the public. And we don't sort of just look at it in isolation. The Charter is the umbrella that we work under every day. I mean, I've been a victim of crime. I'm not, I've defended people that have committed terrible offenses, and I've defended people who were totally innocent. But the public safety and the interests of the public includes the proper and proportionate application of the law. It's not one side of the street or the other, with great respect.
Okay. If you were in a situation where you were defending an individual and the justice said to you that you may provide information or that you shall provide information, what difference would those comments carry? What difference in weighting would they be in your own mind?
If a justice said to me...
Said to you, Mr. Trudell, you may provide this information or you shall provide this information.
Well, I think a justice is always going to say to the defense, you may. Can't think of too many circumstances where the justice will compel. But let's go on the other side of the coin. If I was a crown, and the justice said, "Mr. Trudell, you shall," I might say, "Well, Your Worship, I need an adjournment because it's not available. Because I have done the best I can to put all the information before you. So if you're saying shall, then I'm not prepared to go today. We're going to have to put this over until I can speak to the officer in charge and get some information, or get some information that wasn't available, or the police officer who usually is here and presses the button in 5 seconds and gets his material, he's not available. I don't have anyone to do this. So we're going to have to ask this bail hearing to stand down." That's how it works every day.
Okay, and we've just heard testimony that this information is available in 3 minutes.
Well, that, you know, you're not going to make a decision on the legislation on the basis that the CPIC information is available in 3 minutes. You don't need legislation for that. I mean, your concerns, with great respect, are much larger than that. It's easy to say, look, if the CPIC system is operating properly, and if the information has been downloaded from British Columbia or Nunavut or wherever this person was before, and if the system is working properly and I have somebody to give me that information, then yes, it's going to be available in a couple of minutes.
Well, but Mr. Trudell, right now the legislation is written that they may consider that information. So it's obviously already in the criminal code for a reason, and that's because somebody considered it important enough to put it in there. And so what this bill does is it changes the word may to shall. No, and what that does is that carries a completely different weighting and context to actually the importance of providing that information.
But, you know, with respect, and I'm not arguing with you, it's just you are looking at the bail in microcosm. There are many concerns and many issues in relation to the bail. Primary, secondary, and tertiary grounds. It's a hearing. It's a judicial hearing, and a judicial decision is going to be made. So you can't just take one piece and say that will change it. In my respectful submission, the fact that a person has a criminal record is relevant and is almost always before the courts right now.
Mr. Cooper. Mr. Fraser.
Just following up on that questioning to you, Mr. Elliott, and I asked earlier, but I just want to make sure that everyone's clear on this. The document that was presented, basically a bail report, CPIC, I mean, that doesn't contain any information with regard to the circumstances of the alleged offense or probability of conviction on the charge before the court. So I just want you to comment on that. I mean, you say that the CPIC information can be gathered in 3 minutes, but I guess that's different than what are the circumstances of the alleged offense, right? I mean, that information is produced in a different manner, correct?
Well, sort of, because when we provide information, if I arrest an accused and had him on a charge for break and enter, for example, I'll provide a summary of the information that led me up to arresting this person, because that will be the primary. I can show that, okay, I bring an accused before you. He's here because of a charge of a break and enter, and I provide the summary of what led up to that break and enter before the justice of the peace. Now, to provide background on that information, well, let me reword it this way. If I arrest you, sir, on a charge of break and enter, and I bring you before a justice of the peace to see if you can get bail, but I also have the ability to acquire information that shows you may not be even convicted of anything, but I can show that you have 25, 30 outstanding charges before the courts against you. I think it's pertinent. Even though the accused has not been found guilty of any of these of these crimes, but knowing that an accused has 25 outstanding charges or 20 or 15, I think is very relevant.
I
and that
agree,
information
but I'm talking about circumstances of the offenses. That's different than your criminal record, right?
That's correct.
Okay, thank you.
Section little 4. Okay, that's what he's talking about specifically.
So that's different than the information that you're going to garner from a CPIC report that you're talking about printing off.
Yes, CPIC reports are what the accused has been convicted of, and we can go further into the CPIC report, and we can also see what the accused, as previous charges, has been withdrawn or removed as well.
And do police, if I could just very briefly, do police officers testify at bail hearings sometimes to talk about circumstances of alleged offenses?
It depends on jurisdiction.
Okay.
For example, in Edmonton, for example, I can tell you that bail hearings were always done by police officers. There was a judge, I believe, out of Calgary, I think my colleague already alluded to his or her name, that stated now that police officers cannot do bail hearings unless the summary.
I'm not talking about conducting them. I'm talking about testifying at one as a witness in order to demonstrate the circumstances of the offenses. Do police officers sometimes testify in court on a bail hearing?
Depends on the offense. For example, if it's murder, then it has to be before a judge. So a police officer would be present.
Okay, thank you.
I can just respond to that. A police officer is often available, and Crown Counsel will ask for an officer to be available if they want to put the officer on the stand. to talk about the case.
Thank you. Mr. Cooper?
To Mr. Trudell, you acknowledged, of course, that criminal history is relevant and material to a bail application hearing. There are 3 grounds provided at section 515 sub 10 with respect to the basis in which bail may be denied, and obviously that is at the discretion of the judge or justice of the peace. Is that right?
Justice of the peace will make a judicial decision.
Yes. And how could a judge or justice of the peace exercise their discretion without that information? For example, under sub 10 sub B, public safety, how could a judge or justice of the peace exercise their discretion without having information about the criminal history of the accused?
Every morning when a justice of the peace or a judge takes the stand, goes into the dais, he's thinking about public safety. He's thinking about the interests of the public and how the administration of justice is working. So an accused person who comes before him, judge is going to be thinking, even though it's a primary and secondary ground, the reality of it is the judge is thinking about the public in terms of safety in relation to the release of this accused. And that goes through a judge's mind in every case. And so it's not something that is a vacuum. It's if, however, there is evidence available to help the judge move in one direction or another, then the decision that the judge makes is much more reliable and judicial.
So I would hope you're not suggesting that a judge or justice of the peace should be making a determination on bail without evidence.
No, there'd be a release.
So obviously you would need the evidence,
well,
criminal history, and as evidence is readily available. Thank you.
Just a couple of short questions. I'd like to first start with Ms. McInnes-Wynne. First of all, again, thank you very much for your testimony. In your testimony, you basically talked about, from a very personal standpoint, what happened to your husband, but you also talked about that for you, the core of this bill was changing the word may to shall. As you've heard throughout all of the questioning, there's a number of other elements that have been introduced in this bill which may be of concern to a number of people related to how they're drafted and where they're incorporated. For you, just now I'm talking about for you personally, is for you what's important and what you care passionately about, that for the purposes of proving that the accused has been convicted of a criminal offense, proving that they've been charged with or awaiting trial for another criminal offense, or proving that they have failed to appear under Section 145, that evidence shall be adduced as opposed to may. Is that for you what's important?
It is. I feel like well, this information wasn't provided. And it's just as easy as that, as simple as that, is providing that information for someone to make a decision, the right decision, based on the information that they were provided. If they're not provided that information, how are they supposed to make a decision?
And I understand. That's what I just wanted to simply understand, because there's many different elements, but that for you is the core element.
Yes, it is.
And so, Mr. Trudell, I'd like to then turn to you, and I'd like to move back again to sections 518.1, 518.1c, little 1, little 2, and little Roman numeral 3. I'm disregarding, for the purpose of this question, Mr. Trudell, Roman numeral 4, which I see enormous problems with in terms of the shall, and Roman numeral 5, but only Roman numeral 1, 2, and 3 to say, as you say happens in almost all of the cases, that the evidence with respect to the record of the accused, what they've been charged with and what they're on trial for, and when they fail to appear, and understanding that the most vulnerable are more likely to not appear for various reasons. Can you offer me any reason, sir, why a prosecutor should have the discretion, if that information is available, not to present it?
So it's hard for me to argue that those 3 points, and I'm looking at the wording, I'm saying to myself, does prove add something, right? So that I leave that.
And we'll have to look at that, absolutely.
Right, because that to me is an issue that someone much smarter than me in terms of statutory interpretation would say you missed. But this is symbolic.
Well, you say it's symbolic, but if it's symbolic, then you don't really care if it's there, because
Well,
for
no,
you this is.
I care.
But then, okay, but if for you to oppose or say that you disagree with the word changing, you should have a concrete, in my view, reason why you oppose it changing, not simply saying, well, it's symbolic, it doesn't mean anything.
No.
I get that there's a number of changes to the law that you're disagreeing with, and maybe I disagree with too. But I'm asking you now specifically on that one point, on subsection 1, 2, and 3, changing may to shall, can you give me any good reason why you would oppose changing may to shall for the purposes of the prosecutor lacking the discretion but being required to adduce that evidence?
So here's my answer with respect, and it may not be as good an answer as you might get from others.
Fair enough.
The criminal code and the system works, and these factors are taken into consideration. And with the greatest respect, we cannot change legislation unless it is absolutely necessary as a result of tragic, horrible circumstances. You're talking about changing the criminal code, which will affect entirely across the country. Mm-hmm. And is it a precedent here that you might be concerned with? But let me say this: if that was all that was in there, those three, and you felt in your wisdom that it was necessary to change the criminal code because there was a vacuum, that's your job. And I've tried to help you with mine.
Okay, well, I appreciate that. Anyone else? If not, first of all, thank you again to all of the witnesses. You, I think, brought a lot of information to the committee that not only do we appreciate, but we'll use going forward as we think about this law. Thank you very much to all of you. Meeting adjourned.